My name is Siobhan Mallory. I'm Director of the Irish Centre for Human Rights, and we're really delighted to host today's event, the inaugural lecture of Professor Roja Fazaeli, who will be speaking to us on interrogating gender, agency and authority in law and society. Professor Fazaeli was appointed as Established Professor of Law and Islamic Studies in July of last year. Prior to joining the University of Galway, Professor Fazaeli was Professor in Islamic Civilizations at Trinity College Dublin, and we're very pleased to see some of her colleagues here today. Welcome, and thank you for joining us. She was a Fellow of the College and served also as a Warden of Trinity Hall, a residential learning community of more than 900 students. Professor Fazaeli gained her BA and MPhil from Trinity College Dublin and a PhD in International Human Rights Law from AUI Galway, as it then was. She was, I found online, she was the 17th doctoral graduate of the Irish Centre for Human Rights. Roja was born in Iran and came to Ireland with her mother and sister to commence secondary school. And I'd like to particularly welcome Nasreen Naqshab here today, and to welcome Roja's family in order of importance, Manali and Joe. You're very welcome. And without you, I'm sure this journey would have been much more difficult. Roja came to Ireland at a time of much political change in Iran, and despite many challenges, has continued to engage in feminist activism, human rights advocacy, and political struggles in relation to women's rights in Iran and Islamic feminisms. As an undergraduate at Trinity College Dublin, she already became involved and engaged in activism in Ireland, was translating for asylum seekers seeking refuge and protection in Ireland, and became interested in the intersections between human rights, gender, and religion. During her master's degree, she returned to Iran to conduct research for a thesis that focused on questions of family honour and women's rights in Iran, and has continued, and while there, worked with several NGOs and human rights groups. She has also undergone many challenges to her work as a feminist activist, as somebody working on feminism and women's rights struggles in Iran and from outside of Iran, and has indeed been subject to house arrests and to interrogations and surveillance. She has always been supported in her work from Ireland, and on her return to Ireland, following her master's thesis, she came to Galway to complete her doctoral thesis. So she subsequently took up an academic post at Trinity College Dublin, and also worked with NGOs including Amnesty Ireland. While at Trinity, she was the recipient of a Trinity Research Excellence Award. The categories for the awards are based on the research charter, and Professor Fazaeli won appropriately in the category of cherishing academic freedom, diversity of scholarship, and pursuit of truth. And asking questions, pursuing truth, and questioning feminism and feminisms is something I think that we are all doing also this week, has been a hallmark of Roja's research and her public engagement. She has thought deeply about what it means to engage in feminist struggles, and to engage in feminist struggles within Islam and engaging with Islam. She is also a regular contributor to public discourse on a range of socio-cultural and political issues, and really is the quintessential public intellectual, always very generous in her work, in her scholarship, in her teaching and her advocacy, and willing to take on complex questions, not going for easy answers, thinking deeply about what these questions mean. In addition to her academic work, to joining us in Galway, launching an ERC project and all that goes with that, she serves as chair of the Immigrant Council of Ireland, one of Ireland's leading immigrants' rights NGOs. She is also a board member of the global human rights NGO Frontline Defenders. She is deeply involved with Scholars at Risk, and also with Sanctuary Scholarships and the ideals of the Sanctuary University. Her research, and I think what we will be hearing about more today, is how women's experiences resolve and with Islamic law impact particularly on their family and political engagements and wider societal activism. She explores a multiplicity of Islamic feminisms and engages with traditional religious texts and also looks at how those texts are reinterpreted through the concept of ijtihad. She works in particular on Shia traditions and looks at the various interpretive methods that can be brought to bear to bring a feminist perspectives, new perspectives to older ideals and older religious thought and writing. Professor Fazaeli has always highlighted women's roles in activism, that change did not just happen, did not just come about because of one or two political leaders, but because of the movements from below. So she was a pioneer, I think, really in movement lawyering, in engaging with feminist lawyering within Islam and about Islam, but thinking about engaging much more broadly with religion and religious texts. So Roja has also been a board member of the journal Religion and Human Rights. I met Roja through our engagement with Emory University and the Feminism and Legal Theory project many years ago. She is a faculty affiliate of the Vulnerability and Human Condition initiative at Emory, and she engages always across disciplinary boundaries, thinking about religion and religions and human rights in diverse ways. We are extremely lucky to have Roja with us here in Galway in the short time that she's been here. She has already launched and led a series on Afghanistan and human rights issues and struggles in Afghanistan. She has contributed to discussions about how to expand our engagement with scholars at risk and with the Sanctuary University, and is already looking at ways to strengthen our teaching and our programs. So I'm delighted now to hand over to Professor Fazaeli for her inaugural lecture, Interrogating Gender, Agency and Authority in Law and Society.
Thank you very much, Siobhan. That was the most generous introduction I've ever had, so thank you very much. It's lovely to see, I thought I stepped on something. It's absolutely lovely to see so many faces, friends and students, particularly colleagues and friends coming all the way from Dublin, people I weren't expecting, so just seeing in the audience. Thank you to President O'Hagerty for his generous opening remarks, and again thank you to Professor Siobhan Mullally, both for welcoming me to the Irish Centre for Human Rights and also pushing me to have this event. And I'm also delighted that the Norwegian ambassador Mari Skare has been able to join us in Galway today in order to launch this project on Muslim women's access to justice in Europe. Just going to take my water before I go into it. If you don't mind, we'll move this. So, in terms of inquiry, BILQIS, which stands for Building Conceptual and Methodological Expertise for the Study of Gender, Agency, and Authority in Islam, is a project that sets out to investigate Muslim women's access to justice in Europe by studying how Muslim women in Europe have navigated questions of agency and authority, both historically and in the present day. So the project will proceed by way of comparative national studies organized initially with general reference to the Ottoman Balkans. A study of Islamic family laws is a primary focus, but the hope, of course, is that the project also teaches us to better address gaps in knowledge around law, religion, and society more broadly in Europe. And here I'd like to thank Dr. Nazife Kosogolu and Dr. Joel Hanisek for their research, which has informed this lecture. So both Nazife and Joel joined the project BILQIS in the last couple of months, and already what they've done really had tremendous impact in advancing the work. So one lacuna we've already been able to identify is around the technical and uses and popular understanding of fatwas. And so, with your indulgence, I like to concentrate my remarks this evening around this term, which is so central to understanding how agency and authority work in questions of Islamic law. So, fatwa is a concept that is fairly basic in terms of its structure and animating idea, but which has often seemed to dazzle a bit when addressed by popular media in Europe. So this owes in no small part to the so-called fatwa given by Ayatollah Khomeini in 1989, following the publication of Salman Rushdie's novel, which I'm sure you're all familiar with, The Satanic Verses. So I should say I'm not entirely convinced that Khomeini's pronouncement was a fatwa. In other words, an answer by an Islamic jurist to a specific question. I think it's more likely that it was a hook or an order given by a political, religious authority. I'm actually not going to get into a discussion on the Rushdie fatwa here. However, whether a fatwa or a hook, it has obvious effect. The murder of Rushdie's translator, the disruption of Rushdie's life for over a decade, the chilling effect on freedom of expression, and most recently, the attack Rushdie sadly suffered in 2022. All of these show how important it is to understand what is at stake when forms of socio-religious power are engaged with claims to authority. So while on this topic, on this subject, it's also fitting to remember the late Kevin Boyle, professor of law at the University of Galway and the co-founder of the Irish Centre for Human Rights. He also served as the founding director of the London-based NGO Article 19 for defending freedom of expression and information, and later became the chair of the International Committee for the Defense of Salman Rushdie and his publishers. Recently, a plaque honoring him was unveiled outside outside the Kevin Boyle Moot Courtroom here on this campus. And I can only hope that this project will also advance in some small part the spirit of his legacy. So, to take a step back, what is a fatwa? We can say that it's most simply a legal opinion given by a mufti, in other words, by an Islamic jurist. And importantly, perhaps most importantly, a fatwa is an answer, jawab, to a question, sual or istiftah, in the form of a legal opinion. In this way, fatwas exemplify the intersection of theory and practice in Islamic law. In order to deliver fatwas, mufti must engage in the practice of ijtihad, a form of independent reasoning and interpretation that take into consideration time and place, thus forming an essential link between the legal profession and the public realm. So historically, individuals seeking fatwas delivered their questions on a piece of paper, and the answer was returned to them on the same written piece of paper. These documents became known as Ruqa'at al-Fatwa or Kitab al-Istiftah. And those which were issued by the major jurists were often collected and published as books. And so shortly, I will give some examples of such written fatwas issued during the Ottoman era. However, it's important to note that fatwas can also be given orally. There are even many fatwa call centers where Mustafti, the questioner, the person who asks the question, can call, ask, and receive an opinion from a mufti. So some of these are actually set up by state bodies, particularly within Muslim majority contexts. So one example of this is in Turkey, the Diyanet, which is the government's Directorate of Religious Affairs, administers actually a fatwa hotline that operates under the handle Allo 190. People may contact the hotline directly with their questions concerning specific issues in worship and daily life, and in turn, state-sponsored muftis, both actually male and female, will give fatwas in response. So whether in written or oral form, both the process of question asking and the process of answer giving are subject to a number of conditions. These conditions are found throughout the Usul al-Fiqh, which is rules of Islamic jurisprudence literature, and in a separate literary genre called Adab al-Mufti, which lay out guidelines for muftis for issuing fatwas. So the conditions include that the answer must be absolute, categorical, and detailed. If the answer is given orally, the mufti actually should speak slowly so that the questioner will be sure to understand the answer. The structure of the fatwa is also generally formulaic in nature, most often beginning with Bismillah, meaning in the name of God, and ending with a general phrase such as Allahu Alam, meaning and God knows best. Lina Larsson notes additionally that rules of etiquette also apply to the mustafti, to the questioner, who is actually enjoined to seek the best qualified mufti, show good manners, and know how to pose questions. So now that we have a basic understanding of a fatwa as a legal opinion given by a qualified jurist in answer to question, it can be delivered in, and we know that it can be delivered in written or oral form, and there are certain conditions or customary requirements surrounding the process. In terms of definition, mufti is the fatwa giver, mustafti is the person who asks the question, futya or ifta is the practice of fatwa giving, and istifta is the request for fatwa. So let us actually take an example from Ireland. So I actually came across a fatwa on the HSE website recently, which was very interesting. So I was drawing up a report on Islam in Ireland, and I came across a fatwa posted on the website. So HSE is the Health Service Executive, which of course is responsible for the provision of all of Ireland's public health services. And the fatwa was posted, or is still posted, if you look up actually online HSE fatwa, it comes up. It's posted under CITES immunization subsection under the heading Flu Vaccines for Children. So the fatwa is formatted on the letterhead of the Islamic Cultural Center of Ireland, and is given by Sheikh Hussein Halawa. Some of you here may know him. He's the Imam of the Islamic Cultural Center of Ireland and actually Secretary General of the European Council of Fatwa and Research, which I will talk about later. So the text of the fatwa actually appears both in English and Arabic, and begins with the classical formula of all praise is due to Allah, and may Allah's peace, blessings, and mercy be upon our Prophet Muhammad and his family and his companions. And then the question comes. So it says, as the question regarding the vaccine that contained gelatin made of pork, I, seeking Allah's help, state the following. So it's a very long explanation, so I paraphrase it. So in his jawab, Halwa, the answer that Halwa gives, he basically gives permission for the use of vaccines that contain pork gelatin. So he does this on the basis of interpretation that through the making of the vaccine, the gelatin is transformed into another material, whose characteristics and specifications are entirely different. The justification is given with reference to treatment of chemical transformations in Islamic law. So for instance, Halwa adds that grape juice is permissible, but if it becomes an intoxicant, which is wine, is then forbidden. While this intoxicant, if transformed into vinegar, becomes permissible. That's basically the reasoning. So the fatwa concludes in the requisite formula with the phrase Allahu Alam, Allah knows best. Although it's not stated either in the fatwa or on the HSE website where the question asked comes from, you can assume that the question has been asked by an individual from the Muslim community in Ireland, or even possibly by a public health organization, maybe the HSE themselves, who sought the opinion to ease any concerns around uptake of the vaccine by Muslim community. Studies actually have indicated that there is a history of vaccine hesitancy among some Muslim communities, and this has occasionally been reinforced by Muslim jurists. For example, in 2018, there is a fatwa by an Indonesian Islamic cleric that declares the measles and rubella vaccines forbidden or haram under Sharia because pig components were used to manufacture it. So there are, of course, many more nuanced discussions around the topic of vaccines in relation to Islamic laws. And there are also many contradictory fatwas on the topic. I presented this particular fatwa as a doorway to the current study, not because of the topic, but rather structurally, it gives us a concrete example from Ireland to hold in mind. When we are thinking about the constitution of religious authority and its interface both with local Muslim communities, as well as the state. So it was very interesting to see that HSE has put up a fatwa by a certain imam from the Islamic Cultural Center, while there is diversity of Islamic authority in Ireland. So in the project we are launching today, we are focused on the production of fatwas in answer to questions posed by and about Muslim women in Europe. BILQIS provides a large-scale gender lens through which we are refracting claims to authority and modes of authority in order to learn more about the history and contemporary praxis of Muslim women's agency in Europe, particularly when it comes to accessing justice. And in this regard, we make frequent use of Joan Scott's definition of gender as a primary way of signifying relationships of power. It's clear that Islamic legal studies needs new gendered forms of knowledge to better or at least adequately address the experience that some Muslim women may have in courts of law. Legal systems and mediation or dispute resolution processes when religious identity or affiliation is a defining aspect of the case. So while I'm primarily concerned in the project with the domain of law and justice, as they are articulated within state systems, I also consider it possible and important to weigh the transnational and global reach of religious authorities relating to Islam, specifically their impact upon extrajudicial processes that may be customary in nature and which can also affect women's lives in terms of social soft power and the construction of community-based ethics. So especially when it comes to fatwas, really their transnational reach is really interesting because you can be anywhere and you can reach out to an authority. And a lot of Muslim communities within Europe, they have links to kind of other countries, whether they are new migrants, whether it's kind of through their families. So these transnational links are both interesting and actually extremely broad to try to discern. So family laws provide a significant and discrete focus for this work because we can trace them historically through Ottoman fatwa collections as well as sigil, that is Sharia court register. Hein Gerber, in his excellent study, State, Society and Law in Islam, highlights that one of the main functions of fatwa was to support the case of a party to a lawsuit. The common practice seems to have been to record the fatwas in the court record. And indeed, we have confirmation through the Ottoman period fatwas that they were recorded in total in the sigils of the courts. And many were preserved in the Fatwakhane, so this is like the house for fatwa or the office of the fatwa, where people could come and solicit fatwas. And so it's actually pretty amazing because you can really dig out certain stories from these fatwas and also the court records. But here in this talk, we are concentrating on the fatwas. Therefore, many of these texts are already gathered in archives. Our task is to identify them, study them, and analyze them in order to learn more about the relationship between Ottoman courts and fatwas. and therefore also the changes or points of continuity in relationship between the women, muftis, and qazis. Qazis are judges or religious judges themselves. So basically, the women used to go to the mufti to ask for a fatwa when they wanted to go to the court, so that in the court, the fatwa would help their cases. By doing this from the perspective of the women mustafti, our team is engaging in a process of queering the archives, or what Bashak took terms changing the normative concept of hegemonic positions. Because of its entanglement and impact on the history of Europe, the Ottoman Empire and its interpretation of Islamic law is a crucial, although certainly not idealized, point of study for this project. One additional point here, which should be apparent, but which may need to be made explicit, is that when we refer to the Ottoman period as a point of comparison with contemporary practices, we are not necessarily framing it along a scale of social progression. We often see examples where Ottoman practice was better developed in terms of protecting access to justice for women than parallel European practices in the same time. Similarly, Ottoman records of human sexuality and interpersonal relationships sometimes present as being more open and frank than some contemporary European perspective would expect from a historical Muslim majority country. So this openness with regards to sexuality and interpersonal relations is also present at points in the European fatwa collections, so that we have actually surveyed so far. For example, the European Council of Fatwa, but perhaps because of the current context of discussions around Islam in Europe, these contemporary fatwas do appear to have chosen to steer clear of some issues that are deemed contentious. Although I should stress that these are only initial observations based upon the first few months of this study. So much like contemporary Europe, the Ottoman Empire we are talking about was comprised of a diverse, multi-religious and multi-ethnic population. Ottoman subjects constituted not only Muslims, but also Christian and Jewish populations. This is important to highlight, as we'll see in some examples below, that it was not only Muslim women actually who availed of fatwas to support their cases, but at times also women from Christian and Jewish communities, the dhimmi. So just to say, I don't have examples of this in contemporary times, but in contemporary fatwas also you see non-Muslims asking for fatwas. So this is a continuation, it's not, and you know, could be surprising fact as well. So in fact, according to previous archival studies, such as those conducted by Leslie Pierce, there was actually a highly developed culture of Ottoman women going to the court. Indeed, the ease with which women approach the court has even been equated with the ease that women went to the hammam, or the Turkish baths. As Betul Basharan notes, men couldn't stop women from going to the court or going to the hammam. In the following examples, therefore, I invite you to consider how Ottoman women were agentic subjects within the process of ifta, or fatwa giving. So let's start looking at some of the Ottoman era fatwas. So again, Dr. Kosoglu has already identified some of these fatwas. So the following is a good example of a fatwa given to an Ottoman woman to be used in court. It comes from Fetwaye Feyziye, an important early 18th century fatwa compilation, which is comprised of fatwas of Shaykhul Islam Feyzullah Effendi. This particular fatwa relates to the frequency of marital sex. So I'm reading here verbatim, and perhaps would note the fatwa typically used formulaic fictitious names in order to anonymize the petitioner, or mustafti. In this case, the names used are Zayd and Hind. So to read out the question verbatim, question. Zayd tells his wife Hind, be divorced from me if I ever sleep with you with the intent of ila. So ila is when a man vowed not to have sexual relationship with his wife for a definite period of time. So this could have happened if they had a fight, and so it could be a number of different reasons. Then 4 months passes by, and although he's capable of having sexual intercourse, he does not have sexual intercourse with Hind. Hind becomes mubana, separated in this situation. Oh, sorry, that's the question. Does Hind become mubana, separated in this situation? Answer, very short, yes, she does. So, as seen in this fatwa, in the Ottoman understanding of Sharia, sexuality was not understood as only a male's prerogative. It was recognized that women also have sexual needs and desires. In fact, as reflected in this particular fatwa, a husband's refusal to sleep with his wife for more than 4 months could result in termination of marriage. This was also one of the ways in which a woman could get out of an unwanted marriage, keeping in mind that the process of divorcing in Islamic law was and continues to be biased in favor of men. As a historical note, in the waning days of Ottoman Empire, a decree law on family was adopted in 1917. This legislation introduced a new mechanism for divorce, different from talaq. So talaq is more or less the unilateral right of the man to divorce wife, and muhalla or khulla, which is it's called woman's divorce. It's when a woman forgoes her mah, which is either bride price or bride gift, depending on how you look at it. So basically, a woman pays to get divorce. There was this new mechanism then that divorce, it was called divorce through arbitration council, which was based on the practice of the Maliki school. So there is different schools of law within Sunni Islam, and Maliki would be one of them. Previously, it was not possible for non-Maliki Ottoman women to get a divorce without their husband's consent in some form, even in cases of severe physical violence or marital rape, which could lead to husband's imprisonment. So the next fatwa is a well-known, it's a fatwa from a very well-known Ottoman religious authority, Shaykh al-Islam Abu Sud Effendi, from the 16th century. So if Zayd divorces Hind by triple talaq in their home and denies this in the presence of Muslims, and Hind is not able to provide evidence for her claim, can her claim be accepted as valid if she takes an oath? So you kind of have to read between the lines. So basically what the question is asking or saying is the man has divorced the woman, but still wants to have sexual relationships with her. So what is basically the answer to this? So it says, no, it cannot, but she needs to prevent him from approaching herself. If he wants to have sexual relations with her, and if she cannot save herself by any other means, wait for this, she must add poison to his meal. So, when he dies in this way, in this world, no monetary compensation can be demanded from Hind, and in other world, she will not be punished for this. So she just got a fatwa to kill her husband. What renders the act of poisoning permissible under these circumstances is the fact that there is no marriage because she's been divorced. Within the framework of Islamic law, they are not allowed to have a sexual relationship. Thus, sexual relationship among them would actually constitute adultery. And since adultery was a sin and a had crime, Hind had the right to save herself from this situation, in this case by killing Zayd. So had crimes are seen or are known as crimes against God, and they have specific 7 types of had crimes. So you have apostasy, transgression, theft, highway robbery, and already we we talked about adultery, slander, and drinking alcohol. So they have specific punishments as well for all of these. So in practice, zina was almost actually never punished as a had crime. And still to this day, actually, adultery, and just to explain as well, there's two types of adultery. There is zina and there is zina muhsanah. So there is, but why it's really, really important to actually to punish is because it's almost impossible to prove. You need 4 male witnesses to actually see the act of penetration. So, you know, in reality, it's almost impossible to punish someone on this. But however, this does not mean that this wasn't taken seriously as a matter of conscience. Therefore, this example, shocking as it is, demonstrates the extent to which women's agency was advanced when it was seen as a means to protect religious integrity through personal action. In this case, religious adherence also guaranteed Hind a blameless exit from what appears to have been an abusive relationship. As mentioned, the protection of religious integrity in family law and matters of conscience was not limited to Muslim women under the Ottomans. Many Christian and Jewish women also applied to Sharia courts, especially for issues related to family law as well as property rights, which were well protected for women under the Ottoman interpretation of Sharia. The following 2 fatwas from the 18th century collection titled the Behçetul Fetva also indicates how the institution of ifta, fatwa giving, was utilized by Christian women who wanted to secure Sharia guarantees for their religious freedom. Its related implications, so it has related implications for marriage in this case. So again, reading verbatim, question: after Zayd, who was a Christian, converts to Islam, should his adult daughter Hind, who is a Christian, be forced to convert? Answer: no, she should not. Question, so it's again a following question. In such a situation, if Hind wants to marry a Christian, can Zayd prevent her? Answer: no, he cannot. So as seen in this example, in some cases, Christian women could also use the institution of ifta and Sharia norms to defend their religious freedom. In other words, they were able to use Islamic law against the pressure of Islamic norms, and also to pursue marriages of choice rather than marriages imposed by family. So these are, of course, just snapshots, but they do give us some ideas as to the innovative ways Ottoman women negotiated with power and authority, both within the home and with the mufti. Thus, we see that during the Ottoman period, women were able to claim personal agency in various ways through fatwas. As well, when faced with an action by a qadi, judge, that they perceived as unjust, women might also resort to a mufti to strengthen their hand against the qadi. This form of fatwa shopping continues today. And in realm of contemporary Islamic family laws in Europe, fatwa collections are now often published online with searchable archives, like those of the European Council of Fatwa and Research, or the website of the Shia Marja Tabligh, the sources of emulations. Most of the online forums also provide a page where the Mustafti, these are the people, the petitioner, the person who asks the question, can send their questions directly to the Mufti or the Fatwa Council, or in the case of the Shia Muslims, their Marja. So, therefore, as much as the Ottoman era gives a standard reference and baseline for a study for our contemporary concerns, we must also acknowledge, as Lena Larsen does, that the Muslim presence in many parts of Europe is actually relatively recent date, and therefore implies a social reality and a concomitant need for new ijtihad, so independent reasoning in the giving of fatwas. So this is obviously not, saying that there isn't a history of Islam in Europe, and that's why we're looking at Balkans, because in Balkans, obviously, there is a long history of Islam from the Ottoman times, and also Spain and Italy, which they have much older history of Islam. But within this project, we are looking, apart from the Balkans, also at Ireland, Norway, and Sweden. So specifically with these examples, Lena Larsson's statement stands. Therefore, I'd like to conclude with two contemporary examples that help illustrate a new and emerging collective aspect of fatwa giving, as well as the evolving relationship between local Islamic discourses and the transnational ones. The first example comes from the European Council of Fatwa, which is a transnational collective fatwa body, with actually its headquarters are in Dublin, in the Islamic Cultural Center. And as I mentioned, the very first fatwa, Sheikh Halawa, is the Secretary General of the European Council of Fatwa. In the word of Yusuf Qaradawi, who was their former chair, the objective of this council is to promote uniform fatwa in Europe and to prevent controversy and intellectual conflict regarding the respective issues whenever possible. So one of the issues with contemporary times is religious authorities, like who is able to give a fatwa and who is giving the fatwa. Do they have the authority? Do they have the knowledge? So the European Council of Fatwa in some ways is trying to safeguard that. Now, whether they are doing that or not, that's a different question. The interesting thing I will, instead of saying European Council of Fatwa and Research each time, for short ECFR. So ECFR is really interesting because of the collective nature of the fatwa. So it's not one mufti who gives the fatwa, but it's a council of muftis, and they come from all over Europe, and some of them even from outside of Europe. Qaradawi himself is from Egypt, so there is links with the Muslim Brotherhood, particularly from ideological side. So the ESFR generally receives questions from Muslims living in Europe, and at times from Muslim organizations dealing with social issues. Although it's important to underline that it does not respond to all the questions that are presented. As Alexandra Cairo notes, issues deemed to be too politically sensitive are put aside. Yet, issues pertaining to heterosexual marriage and divorce appear to be evergreen. So the following fatwa is from an undated collection of fatwas published following the second and third ordinary sessions of ECFR. So question, I'm reading it verbatim. May a newlywed man divorce his wife if he discovered that she has lost her hymen? The woman swears by Allah Almighty that she has done so by means other than sexual intercourse, such as practicing sports and so on. The collective response is rather long, but I'll give a snippet of it. So it's about like 3 pages, the response, which is different. When I read the Ottoman fatwas, as you saw, it was like a yes or a no. So here, in this case, there is no serious justification for divorce, particularly that the couple are at the first step of married life. Indeed, it will lead to great harm, affecting the woman and her reputation. Therefore, if the woman's justification is reasonable, as is the case in the question, the man ought to believe her. Only questions considered to be of interest to the Muslim community were taken up at these so-called ordinary sessions. I think they were biannual meetings. And they happen all over the place. Some of them are in Dublin, some of them in Sarajevo. I think one may have been in Norway, but a lot of them do actually take place in Dublin at the Islamic Cultural Center. These questions are distributed in advance to the member of all male council, who each present their own answers. Those answers are then considered collectively. After comments and proposed changes have been received, in some cases a consensus response is reached. And in some cases, the majority view is presented as the response. And there seems to be some dissenting positions as well that are sometimes noted. So the very final fatwa I like to consider is similar in topic to the previous ECFR fatwa. However, the source differs significantly. So this last fatwa was given by Ayatollah Sanei, who is a Shia cleric from Iran, and one of the 54 Shia clerics who currently hold the status of Marja' Taqlid globally. So these are the highest ranking legal authorities for the 12er Shia community. So believing Shias, if they want to ask for an opinion, they usually go to a marja, and each has a specific marja. So there isn't as much shopping around as there might be with the muftis. There are, sorry, I said that already. So whereas within the Sunni tradition, a fatwa is regarded as a learned opinion with considered weight in legal settings, within Shiism, there is an additional positive obligation to follow the fatwa given by one's chosen marja. So it becomes a duty. So usually, when you think of a fatwa, think of it as a legal opinion. So opinion is important. You either take it or you don't. But when it comes to Shiism, if you go to your marja, then there is an obligation to follow it. This would also apply to Shia Muslims then living in Europe who can call the offices of their marja or use their website to submit a su'al or question. So majority of the marjas are actually in Iran, some of them in Iraq, so Shia majority countries. There is one marja in Canada, which is really interesting, but Hosseini Nasab is his name. Yeah, I haven't done much research into him yet. Indeed, the following fatwa from Sanei was published in an online collection directed towards Iranians living outside of Iran. So it responds to the following question, which I will read verbatim. So this was actually published in English, so this is not my translation, but I copied it from the website. So question, if virginity means that the girl's hymen is intact and existing, what is the case of a woman who has been deflowered through an unlawful sexual intercourse with a man, whose hymen has later been restored or repaired by surgery? Is such a woman deemed a virgin when it comes to mahr? So mahr is, again, bride gift or bride price at the time of marriage or divorce. So bride gift or bride price is negotiated usually between the families. It should be between the man and woman, but usually it's negotiated between the families. And a woman can ask for this anytime during their married life, but usually they keep it as a safeguard. So when it comes to divorce, I had mentioned it before, that if they do want to initiate divorce, they let go of their mahr. And if a man wants to divorce them, the man has to pay the full mahr. So Sanei answers, to repair damaged hymen is permissible. It is even impermissible to avoid repairing a ruptured hymen when it's likely that the girl loses face and gets into trouble. However, with respect to marriage, mahr and annulment of marriage, virginity is a matter of mutual agreement concluded whether verbally or by action. So I don't know if that makes a lot of sense. Thus, if a man and woman enter into a contract of marriage on condition that the girl be originally virgin, while she has had her hymen repaired, this will be a violation of the contract terms, and the man will be entitled to annul the marriage. But if, before concluding the marriage contract, the man learns about the girl's hymen having been repaired, and is still knowingly marries the girl, then there will be no violation of the terms, and the man will not be entitled to annul the marriage. However, conventionally, that which is meant in marriage is original virginity, but not a repaired hymen or the like. So yeah, you can understand this yourself. So in both of the fatwas above, the notion of virginity is correlated with a woman's modesty and honor. although studies indicate concerns for preservation of virginity are decreasing with certain Muslim cultural contexts, such as Iran. It's obviously still the case that some women opt for hymenoplasty in order to participate in a prospective religious and cultural narrative of premarital chastity. On the other hand, we also see examples where women use this medical intervention to circumvent both state and social control of their bodies and sexuality. Nasif Sharifi even suggests that for some Muslim women, premarital sexual relations becomes a form of cultural defiance, which is a claim to agency itself. To conclude, I have presented above just a snippet of really a staggeringly large number of fatwas which this project will hopefully ultimately analyze. And I would reiterate that at this initial stage of the project, it's often the question actually raised by or about the woman that's more interesting than the fatwa, the answer given itself. The questions asked provide us with first-hand evidence of the specific social realities experienced by Muslim women. Particularly given the scale of this project's historical and geographical scope, so we are looking at Bosnia-Herzegovina, Bulgaria, Greece, Ireland, Norway, and Sweden. So these questions also give us multiple ways to compare how Muslim women have sought justice in different places and eras, regardless of whether they have been met with justice. As we continue to gather more information about how those specific approaches to justice have been facilitated or frustrated within different legal systems, we can also begin to analyze the degree to which their success or failure has depended upon the relationship between religious authority and governmental policy across time and place. We understand from the examples provided in the Ottoman fatwas that women did bargain inventively as they navigated patriarchal structures. In some cases, in order to get out of a difficult interpersonal relationship, and in some other cases, to pursue interpersonal relationships of their own choosing in autonomous fashion. The examples of contemporary fatwas that have been presented similarly provide us with an indication of the shared interest in women's sexuality as a changing cultural norm for Muslim individuals and communities, whether in Europe or elsewhere. Therefore, we see that both historical and contemporary fatwas, and particularly the questions they respond to, give us valuable insight into the gendered relations governing Muslim communities in a way that cannot be found as easily and as regularly in other sources related to Islamic family laws. We do not yet know at this stage of the project what innovations or established continuities in fatwa production will mean for Muslim women's access to justice in Europe. However, we do know that women's agentic power is already visible in these documents, and that is a very good start.
It's a fantastic project, and I was thinking, how can I possibly comment on the project? And I decided I cannot. But I can perhaps give some context. I'm very happy that Norway is part of this study, because I think that we know way too little about Muslim women's access to justice in Norway. And I think that your approach is something new, and we will benefit greatly from having the research that Roja and her team is about to carry out. So approximately 4% of Norway's population of 5.4 million people identify as Muslims, small part of the population. And most of these people, they are having an immigrant background. So they are either immigrants themselves, or their parents, or their grandparents perhaps, coming to Norway. So that says a lot about their context in a country like Norway. They come from countries Pakistan, Iraq, Somalia, Iran, Turkey, Afghanistan, and Bosnia-Herzegovina. And my perspective, and I'm sure all of your perspectives, are that equal and effective access to justice is a basic right and a prerequisite for maintaining and evolving fair and democratic societies. This is why your study is so important, Roja. There has been some studies in Norway, perhaps relating to this, but far too few. And I'm sure that we will benefit from the contributions of your team. Now, as was mentioned in the very kind introduction of me, I was Norway's ambassador to Afghanistan, and I also worked there before becoming an ambassador to Afghanistan. And I must say that I struggled, and I'm sure I was not the only one, I struggled to understand the complexity of the legal systems in Afghanistan, being customary law, Sharia law, and tying into the formal legal system that was evolving. It was not easy. It was not easy to understand, and it was not easy to understand how legal strategies should be built to ensure women's access to justice. I met and worked with many people in Afghanistan and never seen so courageous, strategic, and competent female leaders as I ever saw in Afghanistan. So feminism was really put into force when I worked there, and I was very, very sad, of course, to see the evacuation and understanding now that many of my friends from Afghanistan, they have fled, and many of these women, they live in countries like Norway and elsewhere in Europe. And I would for sure like to understand how they navigate their agency and authority in these contexts. So very important, Roja. So of course, Norway's tradition is very different from Ireland, and I would say also from the Sharia law. I'm coming from a civil law tradition, not customary law. And I think that context is very important to understand when you embark on a project like this. And for me, when I'm thinking about access to justice, it's of course access to justice across the legal disciplines. So it's access to justice within family law, environmental law, employment law, corporate law, criminal law, not the least, so across the board. And I understand that you need to perhaps define the focus on your study also in Norway. And I would like to emphasize, what this Center of Human Rights is about and how we, as Norway, looks at this and how we implement the human rights in Norway. You all know that the human rights are universal and that the states have the primary responsibility for ensuring that these are adhered to. And Norway has ratified most of the central human rights treaties and conventions and all the protocols. But to take full effect in Norwegian law and Norwegian society, they have to be incorporated into Norwegian legislation by an act of the parliament. So in 1999, the parliament issued an act where they gave 5 of the most significant human rights treaties prevalence for other legislation in Norway, meaning that if there is a conflict between the human rights and national or domestic law, the international law has prevalence. And I think this is a very, very important aspect of my society. And the Norwegian Constitution, which is from 1814, was changed in 2014 when we celebrated its 200 years, and it was all incorporated, the rights of life, liberty, equality, privacy, a fair trial, freedom of expression, assembly and movement, as well as rights relating to children, work and the environment was incorporated into the Constitution. So I know it's been said many times, I think my Prime Minister said it like 30 years ago, human rights are women's rights, and women's rights are human rights. And I would like to end my little comment by paying tribute to Narges Mohammadi from Iran. She was awarded the Nobel Peace Prize in December last year. She was awarded this prize for her fight against oppression of women in Iran and for freedom for all. She was deprived of the opportunity to come and collect the prize. She is in prison, and I understand her sentence has been extended. So her children came to Oslo and accepted the prize on her behalf. She stands as a guiding star for all of us. Women, life, freedom. I wish you good luck.